Person whose name says Woods, unmute and identify yourself for the court.
How you doing, Mr. Woods?
What's your name? That's not your name.
Darrell Woods.
Oh, okay. Your lawyer just left, Mr. Woods.
Yeah, we was waiting for an hour.
Yeah, you haven't been waiting for an hour, Mr. Woods, because I'm so good at my job. I would never let a person just sit in my waiting room waiting for an hour. Now, I can tell you what occurred is that I brought your device into the courtroom several times. I shared my screen just like I just shared my screen. However, you never connected. So you haven't been waiting. You haven't been waiting. You haven't been waiting on us for an hour. But we definitely. I apologize. What you say?
I said I've been waiting for an hour, miss. I got screenshots.
First of all, my name is not Miss. I apologize. My name is not Miss. Now, if you're going to address me, you can call me Judge. You probably can call me ma'am. You definitely can call me Your Honor. But
I'm sorry, Judge.
But I'm not Miss. I'm not Miss. Number one, I'm not Miss. So number two, as I indicated, we have brought your device into this Zoom room at least 3 times. And on each occasion, when I shared my screen like this, your device did not connect. And then I put you back in the waiting room several times. Your lawyer has already been here. I have gone to a breakout room with your lawyer and the prosecutor. We have discussed your case on the record. Why would we do that and just leave you waiting in the waiting room? We would not. So hold on while I try to get that other prosecutor back, and then we can tell you what's going to happen with your case. Were you able to reach Miss Cole? Because I don't know why she left.
She didn't answer for me. I left a message and I can email.
No, call her back. I need her back. I need her back. We're in court. I mean, can you stop stretching and yawning on the screen? My goodness. We're in court. Madam Clerk, do I have paperwork from Mr. Waldrop?
Check your email, Your Honor.
All right. And can you call Mr. Toussaint, find out what's his situation? Because he got disconnected in the breakout room and he hasn't logged back in.
Okay.
All right, then I'm ready on Waldrop. This is case number 22-457-7401, the people of the state of Michigan versus Deshaun Waldrop. The defendant is charged with 1 count of assault or assault and battery, 1 count. Hold on. Hold on. Excuse me. Somebody tell me what happened to count 3. Somebody? Anybody? Can somebody tell me what's going on with count 3? Does count 3 still exist?
Second, Judge.
Okay.
Judge, for the misdemeanor, I only see 1 count.
No, I'm not talking. I'm looking at, I'm looking at this tether unit violation. That's all I have.
Oh, okay.
1, assault or assault and battery. Count 2, malicious destruction of property. Count 3, home invasion, 2nd degree. Something
Okay.
there had to be a felony somewhere. And then
But I don't have a copy of the Tether report.
Neither do I, Your Honor.
oh, Madam Clerk, can you please send the tether report to the attorneys, please?
Yes, Your Honor.
And it says a copy of this report was sent to Judge Mark Slavens and Judge William McConaughey. Judge Bryant's name is nowhere on this paper. So what are you pulling up? You saying you only see 1 count?
I see a misdemeanor case number 2204 57 7401, which is a pretrial before this court on look at it again.
So maybe the felony is case number 19008169001. And then he also has case number 224454501.
And there's a 22060. Yeah, I would need the tether report so I can see what he does have a tether on the misdemeanor case that I just cited, Your Honor.
But he also had, so now that I'm reading down in the 2nd paragraph, appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Cammy appearing on behalf of Deshaun Waldrop, who consents to my appearance on his behalf. Is that correct, Mr. Waldrop?
Unmute yourself, please.
Yes.
And could you please state your full name for the record, please?
Deshaun Waldrop.
All right, so Mr. Waldrop is before the court on the tether violation. Can somebody please look up case number 1900816? Now that might be already across the street.
Yeah, it's across the street.
No, Mr. Waldrop, no.
So I have that case pulled up, Judge.
And is there a tether on that case?
So it looks like the home invasion 2nd degree was dismissed by the court. And the only count that I see that Mr. Waldrop pled to was.
So why is his case across the street with Judge Slavin?
He's on probation on that felony case, Judge.
I need the deputy. So if he's on probation to Judge Slavin, why would they send Judge Slavin a copy of this report unless Mr. Waldrop was on a tether to Judge Slavin? And if he's on a tether to Judge Slavin, I'm not addressing this tether.
Your
Yeah.
Honor, Janice Stevenson, also on behalf of Mr. Waldrop, and Your Honor, we don't believe this matter is properly before this court, and that the case number that's referenced is not the case number. Is not a misdemeanor case number, Your Honor.
Yeah, there's 3 case numbers on here. Now, 2 of them are misdemeanors. But there's no way I'm going to address a tether if he also has a tether on the felony. So I need the deputy. I need you to stop being dramatic. I need you to stop doing all the stuff you're doing. And I need you to ask the deputy to come to the screen, please.
Oh, okay.
You see something different, Ms. Stevenson?
Only in that paragraph that starts with, on June 21st, the subject was enrolled in the Wayne County Sheriff's Tether program for those
It
2
does say
misdemeanor
he's
cases.
incarcerated, but then it says the subject also has out of third circuit, blah, blah, blah. He was explained to an agree. Deputy,
Yes, Your Honor.
I need a clear understanding of whether Mr. Waldrop has a tether condition on his felony case. On his felony case. He has, this report lists 3 cases, and I need to know if there is a tether condition on the felony case.
Yes, sir. Let me call and find out.
Okay, thank you. So while he's finding that out, with respect to the 2 misdemeanor cases, he has a malicious destruction and an assault and battery. It says that the violation, well, and he was on, let's see. So they're saying he was in an exclusionary zone. House stop at subject last listed location. Immediately identified, revised as a violation. At the time, he was in violation of the court order house arrest. So he was placed on house arrest by somebody, probably Judge McConaughey and the magistrate. Don't know if Judge Slavin's put him on any type of house arrest. And then, sir, stop it.
Yeah, I really want to say
I don't know how many times I'm gonna ask you to stop.
I really want to say something.
But you're not going to say something at this time.
Okay.
With respect to the tether conditions placed on by Judge McConaughey, counsel, what's your request, or what's the situation?
Your Honor, Mr. Waldrop understands that he violated the tether location in that he left the house to get some clothing because he has no personal belongings in the location he's tethered to, and it won't happen again, and he understands that. And however, he's had no contact with the complaining witness or any contact with the location of the complaining witness, and he will not. And Your Honor, he hasn't been able to, he's currently employed, and if the court is not inclined to remove the tether, we ask for a curfew so that he be permitted to leave the house for work if possible.
Well, what you say, that explanation don't even make sense. So he was explained the tether conditions. He was explained the house arrest condition. He's tethered to a location where other people are. And he is the one that's on house arrest, but he said, I'm going to go get my stuff, as opposed to sending some. I refuse to do the hearing. Okay. I'm going to refuse to do the hearing at this time. And then you all can go talk to Mr. Waldrop, because he has a lot to say and he's being very disruptive. And if he do this one more time on court to me, let me say this to you, if he does this one more time, then I'm going to cut the whole proceeding. So he clearly has something he needs to say to the lawyers. But he's going to stop being disruptive to this court proceeding. So you all go back in there and talk to him and find out what it is he so desperately needs to say that you all are not saying on this Zoom. Because in a minute, I'm not going to hear the tether violation. And I'll just send it back to Judge McConaughey or Judge Slavin. It's great to see you. Okay.
I'm pleased to be seen, Your Honor. Aloha from Maui.
Well, I was thinking,
I'm a little underdressed. Sorry.
Let me tell you, when I saw your shirt, I'm so glad you said that, because I'm gonna tell you, when I saw your shirt, you know, y'all know sometimes I could be silly, and then I have to remember I'm the judge, and so sometimes I can't just be silly. So when I saw your shirt, I was thinking, I mean, he sure looked like he's somewhere that don't have nothing to do with court. And so I'm glad you said that. Your client might be one of these people that's in my waiting room, but that's unidentified. I can't remember, but they've appointed you to Mr. Smith, right?
That is correct, Your Honor.
All right. So just give me a second.
I'm standing by.
Okay. All right. So I just brought some people in, and the first person I'm going to address is the county jail with respect to Mr. Waldrop. So Ms. Cole, good morning, and just give me a moment. So good morning, Deputy. I'm assuming from the Tether unit. Good morning.
No, I'm not from the Tether unit.
I'm from the
video unit.
Okay. So good morning. So I had a question about Mr. Waldrop, and whether or not on the felony case that's listed in the Tether report, whether there's a tether ordered on that case. So that's my question. Did you need to, it's in front of Judge Slavin's. I do have the case number that's listed on there, but we were trying to figure out, is there a tether imposed on that case as well? Because otherwise I didn't really understand like the significance of it in the report. And I didn't want to give Mr. Waldrop any false information when I address his tether.
It is a $5,000 personal bond with GPS tether, no contact with Alicia Hunter, Your Honor.
Hold on one second. Chief was texting me. All right, say that again. So you're talking about the felony case, his felony case. That's the bond you're giving me right now.
Yes, that's the case that is before Judge Slavin's. That's the one you asked for?
Yes, sir. Okay, tell me that bond again.
It is a $5,000 personal bond with GPS tether, no contact with Alicia Hunter.
And then do you know whether the GPS tether ordered by Judge Slavin's, is it a house arrest tether? Or you don't know the restrictions?
The only restrictions I'm showing on the Frank Murphy case is no contact with Alicia Hunter.
Okay, okay.
I have a Case number, it's out of 36th District, 22,
Right.
5777401. That is dated 6/9, so this may be out of date, but it does say GPS tether house arrest.
Okay.
Allowed from Horton Medical.
Awesome. All right. That's exactly the information I needed. Thank you so much, Deputy, for logging in. I appreciate it.
You're welcome, Your Honor.
All right. Okay. So now that we know that I was correct, and that's probably a good reason that's probably a good, that's probably why I'm the judge. Because I know that you have to look at the actual records, Mr. Waldrop, and that's why I told you to stop. So the actual record has Mr. Waldrop also on a tether to Judge Slavens. Now, it appears that the tether to Judge Slavens is not a house arrest tether. So what I will do with respect to his tether on the 2 misdemeanor cases, I won't remove the tether now. I should have asked the deputy. Okay, I won't remove the tether now. But when he comes back to me for his pretrial, if he is still on the tether for Judge Slavens, if Judge Slavens hasn't removed his tether condition by that time, then maybe I'll remove mine. Or let me hear from Miss Ritter. Where's Miss Ritter? With respect to the tether condition on this case, who is the complaining witness with respect to the malicious destruction of property? Is that the same complaining witness with respect to the assault and battery?
No, Judge. So the complaining witness on a malicious destruction of property is actually the same complaining witness on the felony case.
Oh, okay. All right. And then it's a different complaining on assault and battery.
That's correct, Judge.
Okay. So then I'm definitely going to keep the tether on my case right now. When is he scheduled for pretrial for my case?
August 7th, Your Honor.
Okay. I'm going to continue the tether. I am going to remove the house arrest condition. So I'm going to continue the tether. I'm going to remove the house arrest condition. Yes, the house arrest condition. And I'm going to put a curfew of 11 p.m. to 6 a.m. Does that address his work schedule?
Yes, Your Honor. Thank you.
Okay, 11 p.m. to 6 a.m. So from 11 p.m. to 6 a.m., he's on house arrest. And then he can go outside after 6, and then he have to be back home by 11. All right? And then no contact with complaining witnesses. Okay? See how I do my job so well, Mr. Waldrop? I mean, I sometimes I amaze myself. Okay. All right. We're all set. Mr. Waldrop, I wish I could tell you that they're going to release you today. However, you have to wait for the tether now to become available again. So as soon as the tether is available, and even if I removed mine, you still have the tether for Judge Slavens. So you would still have to wait for the tether to be available. Okay.
Judge, sorry, I got a question.
Yes, sir.
So basically, I want to say thank you. I'm gonna make this brief. I just want to say thank you, Your Honor. And my downfall is I need to listen to the courts. Okay.
Because see, you would have thought if I had removed your tether, Mr. Waldrop, you would have been in jail mad because you thought Judge Slavens didn't have a tether on you. And
so am I getting out of jail?
You're going to get out of jail as soon as they get the tether. They're going to put you on the tether.
Okay. Yeah. You know, what I kept raising my hand about everything has to be explained. You know, okay, honestly, you probably wouldn't believe this, but basically I had called him when I got out of jail.
Is this about the case?
No, No, it's about the tether. It's about the house arrest. I don't want you to
Oh.
think like this guy just deliberately just up and left, like I'm a lunatic.
okay.
No,
No,
I called him. I said, hey, dude, I need to go get some clothes and stuff from Myers. He said, yeah, go ahead. Then the next day he called me and told me, he said, hey, dude, this is a misdemeanor case. You're on house arrest. I don't understand it. And then he like, dude, if you need to go somewhere, just let me know when
that's
you
the
will be
guy
back.
at the Tether place?
Yes.
Shame.
I didn't just, listen, I wouldn't just up and leave like
You
a
see how he
lunatic.
set you up for failure?
Boom. Why would I just up and leave? Like, why would I be leaving? You know, unless he told me like, hey, it's okay.
Right, but I just lost Paula Cole. I just lost Paula Cole. Can we call her back?
Okay, well, I'm out of here. So I guess I'm out of here, Judge. Okay.
All right.
So I'm going home, basically.
Yeah.
Judge,
Yes,
I gotta go
Stein.
too.
Yes,
I gotta go.
Mr. Stein.
I'm gonna let this young man talk because it looks like
No, he gotta go too.
I'm going home, right?
As soon as you get a tether. Mr. Toussaint, I'll let you know what Miss Cole says.
Okay, so I'm out of here.
All right. I lost Paula Cole. I need her back. Let me find out if one of these devices is your client, Mr. Boffman.
Be clear to everyone. I've sent him a copy of this motion and I'm asking the court to sign.
Okay, we'll go on the record. The court is calling 2023 CR 3281, State of Texas versus Eugene Boyd. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
For the defense?
Melissa Christian.
Are you Mr. Boyd?
Yes, ma'am. Yeah.
All right, your attorney has filed a motion to withdraw. Are you aware that your attorney wishes to withdraw?
Yes, ma'am.
All right, the reason she's withdrawing is because her representation has concluded. Was this an appointed case?
It was, Your Honor.
All right. So once the plea agreement was entered and you accepted the plea bargain agreement, her representation at that point ended. So she is filing a motion to withdraw so that on the record, her representation can be ended. Do you understand?
Yes, ma'am.
All right, your motion to withdraw is granted.
Thank you, Judge.
You're welcome. Yes, you may be
Thanks.
excused. Now, Mr. Boyd, we have an issue. Do you know what that issue is? And we can go off the record. The issue is you're supposed to go to, first I sent you to felony drug court. And you didn't want to do that.
It's not that.
I know. Here's the thing. I've told you this time and time again, and I don't know how many times I have to tell you this.
But this.
Listen.
Okay.
I am in charge of setting conditions of probation, not the state, not your attorney. When you signed your agreement with the parties, your plea bargain agreement, and I go over the pleas in great detail so people can understand. This right here, I let people know that this is outside the agreement. These are recommendations from the state and the court does not have to follow that. Do you understand? And your answer was yes, because if your answer would have been no, I would have said, all right, you all need to go back and confer. Let me tell you what this note says, and it's in all caps. The parties are not allowed to make binding agreements regarding the length of community supervision or the terms and conditions of community supervision, which are totally dependent upon the court's discretion. The following recommendations do not constitute part of the formal plea agreement. However, the state, both parties, make the following non-binding recommendations. So I know you keep saying, I'm not supposed to be at safety. I'm not supposed to be in felony drug court. Guess what? You are, because I ordered it. And there is no agreement that could have been made between your attorney or the state saying these are the only conditions he will accept. So let me just tell you what's going to go down. I'm not having another compliance with you. You're either signing to go to safety or a motion to revoke is going to be in it. The end. Do you understand?
Yes, ma'am.
You have been back before me numerous times with me explaining to you why you are being recommended for different things. I don't send anybody to felony drug court unless they have a drug problem. You have a drug problem. I don't send anybody to safety or SATF if they don't have a drug problem. You have a drug problem. And for some reason, you don't want to acknowledge it. So maybe you want to go to prison. If you want to go to prison and do your time, you're looking at 5 years in prison, potentially. So if you would like to do your time, then stop wasting everybody else's time. I'm not referring you back to felony drug court. I referred you there twice. And I received the note said, you were rejected. Client was offered felony drug court for the second time and refused. So you're not going back to felony drug court. So you're either going to SATF or a motion to revoke will be filed. So which do you prefer?
I'll go to Saturday.
You are signing that today. And if you do not sign it today, a motion to revoke will be filed and we will be hearing whether or not you should go to prison. Do you understand? Is there anything else you don't understand?
It's fine, man.
All right, thank you.
Thank you.
Oh, I'm sorry. I need to write in that file.
Lorraine Efron for defendant or ready, Judge?
And are you Mr. Gutierrez?
Yes, sir.
All right, you entered a plea of deadly conduct with a firearm as a third-degree felony. According to the plea bargain agreement, punishment is to be assessed at a cap of 10 years. The state is remaining silent on your application. And then there are no contact orders. Have both parties had a chance to review the PSI report, state?
Yes, sir.
Defense?
Yes.
Any objections to the PSI report, state?
No, Your Honor.
Defense?
No, Your Honor.
All right, the state is silent. Defense, do you have any witnesses?
Just, if I may, I have a couple of paycheck stubs or 3 paycheck stubs of my clients that I'd like to offer. And I had given the state an opportunity to review them. And then I have some photographs of my client with his daughter, if I may offer those to the court for your consideration.
Yes.
Judge, state sign.
All right.
I also have a letter from his boss, Judge. I need to find that.
Okay.
Oh, gosh. I didn't make. I'm looking for the letter from his boss, Judge. I
All
have
right,
read-
if there's no objection from the state, if you want to make a proffer what the letter says, I do believe he's employed.
Yes, Your Honor.
You can look at this. It's a
It
matter of
just,
public
it
record.
speaks to his, promptness as an employee, as a valuable employee, and as to him being consistently employed and being able to be continued to be employed, should the court grant this application, to use him as an employee. Judge.
Okay. All right, is there anything else?
Mr. Gutierrez, on his behalf, Judge, has had a lot of time to reflect during the pendency of this case. He has 3 children, including a daughter whose picture I showed you, his biological daughter. And he has recently reconnected with her and reestablished good communication with her mom and with her. And he feels extremely motivated now between the opportunity he has at work to do well and his relationship with his daughter being very positive. And he wants to be able to continue in that path and show the court that he can do better. I see the PSI recommends intensive outpatient I think their focus is probably alcohol. And if the court were to deem any other conditions of free, he would absolutely comply with whatever conditions the court would deem appropriate. He has been on GPS for a considerable amount of time while this case was pending. I think maybe since
So it's been a year or 2 months.
a year and 2 months, he's been on GPS with no violations. And I think that speaks to his motivation to do better and his respect for the court orders and his ability to be a successful probationer. And I hope the court will take into account, that's a significant amount of time. He was on full GPS house arrest, and then that converted to partial where he's been able to work, but no violations. And so we're hoping the court will give him an opportunity to show the court that he can be successful on probation.
All right, but here's my concern and what I don't understand. How old are you?
37.
You're 37. I don't understand going to a bar and people tell you to leave. And your answer to people telling you to leave is, I'm going back to my vehicle and I'm getting a gun and firing the gun. I don't understand that. So I don't know if he wants to be under oath to explain that to the court, but this is what I'm trying to wrap my head around. I don't understand why people's first answer to any situation is, let me go get my gun.
Well,
And I know people, I don't know, people seem to have a love affair with weapons. And if you want to have a love affair with the weapon, then you need to treat the weapon with respect, because the weapon can kill if it's in the wrong hands. And I'm just trying to figure out, there's an incident that happens. Somebody calls you out your name. Oh, let me go get my gun. I'll show you who I am. Somebody tells you to leave a bar because, I don't know, maybe you're intoxicated. Maybe there's some altercation. I don't understand why people don't leave.
I would say that the offense report and PSI reflect that he says he had 5 beers and 3 shots. So I would submit to the court that he was not thinking.
Yeah, I mean,
He
to
was,
me,
and I'm not saying that intoxication is a defense or mitigating at all. I'm just saying that, it causes a loss of impulse control. And
I mean, I understand what you're saying, counsel, but sometimes I think alcohol gives people courage to do what they otherwise wouldn't have done, as opposed to, oh, my inhibitions are released. Yeah. So I don't know if he wants to speak to the court or not, because I'll tell you, I'm leaning towards sending you to prison. I haven't heard anything that would suggest to me that I shouldn't send you to prison, because I don't know somebody who takes some shots. I realize you were intoxicated. I'm reading it, but people put you out of the bar. And it's on Mother's Day too.
It was 6 guys that took me out.
Yeah,
So
because you wouldn't leave. When people tell you to leave an establishment, just leave. So I don't understand why I should give him deferred adjudication when he went to a bar. And according to things he's saying, somebody tried to come on to his fiance. That's when you leave. And they told him to leave. And maybe they were very rough in pushing him out of the bar. I will give you that. They were rough. They bruised you up, maybe push you out of the bar. But that's where you leave and go home. Hopefully you were not driving with those tequila shots. And then, or if you don't want to leave and you stay in the parking lot, you call the police, but you don't tell people, well, I'm going to show you who I am. And then you go to your vehicle and get your gun. Did your fiance say any, did his fiance say, hey, what are you doing? This is crazy. Let's just go home. Okay.
The altercation at the bar wasn't good. I think that there were probably others there who also had weapons. Again, not to say that there's necessarily a defensive or mitigate, but maybe it's a little mitigating. It just turned out to be a very rough circumstance. I'm not making light of the offense because obviously it's serious. And I think that the PSI speaks to the alcohol being an issue and intensive outpatient. So I think if the court would give him to address the alcohol and maybe perhaps anger management issues, maybe that would help to lessen his future risk to the
And I
community.
see that there are other people who had guns, because I see Eric Fields, who's one of the complainants, not the main complainant. He says, I just want my gun back.
Yeah.
This is Texas. We just want our gun back.
Right.
So, ma'am, I haven't been in trouble since 2005, and being at that
You want to
bar,
raise your right hand to be sworn in? Can you, do you solemnly swear and affirm that the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Guadalupe Gutierrez,
And let me just tell you, your statement about you haven't been in trouble since what time?
2005.
I haven't been in trouble since 1969, and I'm putting it at 1969 because I was potty trained by then. And I didn't pick up any criminal cases. I always tell people when they tell me, I haven't been in a gang, I don't do drugs, I haven't been in trouble. It's like, do you want a cookie for that? That's what you're supposed to do. So let's not start with, I haven't been in trouble since this date, because I'm looking at your criminal history and one of them is terroristic threat. And then criminal trespass. And is this criminal trespass with a weapon?
That was with a box cutter at my aunt's bar. I just left work.
Okay. And then the theft of a vehicle.
That was back in 04.
And now we're back here.
Yes,
And on on the probation from 2013 on the criminal trespass with a weapon, your probation had to be extended. Then on the theft case, a motion to revoke was filed and you were sent to TDC. And now you have this that started as an aggravated assault with a deadly weapon, and the state reduced it to a deadly conduct 3rd degree. So speak to me. Why should I give you deferred? I don't understand why I should.
Well, man, I'm not a good talker, but
That's
you
okay.
told me not to say how it started, but
No,
I
go.
was trying to prove a point that since 2005, I haven't been in trouble, and all those years I was in the oil field for 15 years and I've never had my daughter. So now that I got my daughter, it's a blessing to me because I always wanted it. So now I have an opportunity to be a father and I don't want to mess that up.
I mean, but you have.
I understand.
I think the reunification, if you will, sort of took place after this offense. Is that correct? Meanwhile, you've been on probation with your daughter.
Yeah, it's been good. It's just like I've been on the monitor, and I can't blame nobody else but me. But it gets me kind of angry because I can't take my daughter out other than be with her in the living room.
Well, I don't know why you angry about that. That's all on you.
That's what I just said.
If you would not go to a bar drinking to the point of intoxication and you're in your 30s, you're not a teenager who doesn't know better.
Yeah.
I think that if the court would give him an opportunity for some form of treatment, I think he would welcome that and appreciate that opportunity.
I just don't think he's a good candidate for probation. I mean, shooting up a bar, and it wasn't.
It was outside in the parking lot.
I see that coming. Thank you. And State, I know you're silent.
Yes, Judge.
Is our applications for probation, for community supervision and deferred?
Yes.
I don't know if it makes a difference to the court. I don't think it necessarily does, but we can withdraw the deferred.
Now, see, this is what I'm reading, and this is my problem. I can understand people being angry and getting upset with people. I honestly don't ever understand people pulling a weapon, because I always taught if you're going to pull a gun on somebody, you need to know that you're to kill somebody, and don't pull a gun unless you're going to use it. That's what I was always taught. But what it says here in the police report that you stipulated to, I contacted Jason, who is the manager and point of contact for surveillance. Jason provided me with footage from one of the cameras. Jason said he was working on getting footage from the other cameras as well. The footage showed Guadalupe, that's you, being taken out of the bar. He walks to his car and pulls out a small handgun. Guadalupe pointed the gun in the air where 4 spent shell casings were found. Guadalupe and Melissa got into the vehicle and he pulls up to the curb. Eric can be seen in the corner near a white car. Guadalupe opens the car door and his hand extends out. Guadalupe then lowers his hand with the gun and points it toward Eric.
I never pointed the gun at anybody.
I mean, that's what they say is on the video. I mean, this is video. This is not.
And I showed her that when I saw the video, I pointed it.
Well, because it's surveillance, some parts of it are a little clearer than others, but as the car drives out, it's a little bit less clear because of the angle of the camera.
Okay. All right. Is there anything else from either side?
Nothing from the state, Judge.
No, Your Honor.
All right. How old is your daughter?
7.
Okay. All right, this is what the court is going to do. The court is going to find you guilty, sentence you to 3 years in the prison, give you credit for any time served. There's to be no contact with Eric Fields and Lefty's Draft House. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, and because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. I did take into consideration that you have a child and that you want to be in her life and do better, but you're going to have to start making better decisions. And it's obvious that you can't drink alcohol at all. So no alcohol, you understand? All right, good luck to you. Who's here? Court is calling 2023 CR 1952, State of Texas versus Michael J. Duran. Can I have parties announced for the record for the state?
For the state.
Defense?
Sorry, Sean Sheffer for defendant, Your Honor.
And are you Mr. Duran?
Yes.
Counsel, have you received all the discovery and did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Mr. Duran, I'm showing you what's entitled Application for Deferred Adjudication or Community Service. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Showing you what's entitled court's admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with injury to a child bodily injury intentionally and knowingly? That's a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? You need to speak up.
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
He had, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Duran, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state recommends deferred adjudication. There's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of your plea bargain agreement?
Yes, ma'am.
Defense?
Yes, sir.
State?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, or there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
That time, he has worked with CPS. The child was never removed from his custody. Child did very well with him. He did everything required. They ended up closing the case. It was not a legal case, Your Honor. He is just requesting, he understands he did wrong, that shouldn't have happened. And he's actually also already started a family violence class also, Your Honor. So we're just requesting the court to follow this recommendation.
So were you the CPS attorney?
No, that was not. He, like I said, Your Honor, there was actually never a legal case, Your Honor.
Okay. Anything you have to say for yourself?
Yes, I was, that day I was disciplining my child like a parent should. He acts dramatic and he was trying to, I understand what I did, but I'm trying to.
Yeah, you're trying to shift the burden on him.
Explain.
I don't believe he's trying to do that, Your Honor, because we had discussions. He understands
Well, he's
he went
saying
way
his
too
child was
far.
asking.
He went way too far. It shouldn't have happened.
He's saying that his child acts dramatic. That's what he said. Dinah, did he say that? Excuse me?
He did, Your Honor.
So he hasn't learned anything.
I disagree with that, Your Honor. Having
Well,
known him for
What have you
this
learned?
time.
I learned how to talk to my child. I'm always being there for him. He's always coming for me to advise. He gives me this random, I love you, I hug you. I'm always.
No.
Um,
Here's my thing. You told me that he was acting dramatic. You told me, and if the record is not clear, or if I'm remembering things incorrectly, please correct me. But you told me that 1, your child is dramatic, and 2, You started by saying, I was disciplining my child as a parent should. That's what you told me. So how does disciplining a child as a parent should result in a child having a belt mark on their face? And was that being dramatic? Because that's what it says in the police report, that he had a belt mark on his face, belt mark on his arm. And how old was your child at this time? What, 9, 8, something like that?
Yes, ma'am.
So basically, what you have taught your child is that your child needs to fear you, which means that if your child accidentally sprays something in somebody's food, he can't tell you because he knows what's going to end up happening. He's going to get hit with a belt across his face. And I don't know why people think disciplining children equals, let me pull out a belt, let me beat you with a belt, because this wasn't let me tap you with corrections. And now you get an attitude with me. And let me just tell you, I will send you quick, fast, and a hurry as a condition of your probation to the Bexar County Jail or either to the state jail facility. And you can see how your discipline works with other people at the jail if it comes to that. So I'm telling you, when you beat a child, this wasn't discipline, this was a beating. When you beat a child, what they learn is to fear you. And you are a grown man hitting on a child. If somebody, let's say, for example, you're at somebody's house, they invite you over, you're sitting at the table and you drop your food on the ground or on the carpet, and it's white carpet, and they get angry. And so they take a belt and slap you across the face. And they tell you, well, I'm just disciplining you because you knew this is white carpet. I told you to be careful not to spill anything on my carpet, and you did. You know what you would do? You would call the police and you would file charges because that person hit you. So you've gone beyond disciplining your child. And I don't know why people don't understand that. And you can say your child out of the blue is saying, I love you and all of this. Sometimes, you know why they're doing that? Because they're walking on eggshells. Because you have put fear into this child. If this child were to pick up a criminal case, you know what they'd come to court and tell me? His attorney would? He suffered trauma. Well, what trauma did he suffer? Well, his father beat him. They're not going to come in and tell me the father disciplined them. They're going to come in and tell me my father beat me. And that's what this was.
It wasn't like that, Judge.
Did he have a belt mark across his face?
I can't recall. I don't remember. I remember him just ducking, and usually when
just ducking.
Usually I try to punish him, send him to his ground him, take away his video games because he does wrong. He understands that.
So why did you beat him with a belt across his face? Is it because the girlfriend came to you and said, this is what happened?
No, that wasn't the case at all.
Yeah, so why did you beat him?
It was just, he was acting up during the day, and it was.
Doing what?
Well, prior to that, we had went swimming, he had jumped in the deep end, and I told him, don't do that. So I went after him, and then when we got out, he kept on pushing me, acting like he's gonna push me into the water. So we go out to get food.
Who's your daughter's mother? Who's the same mother?
Yes, ma'am.
Okay. Finish your story.
And so my daughter is like getting irritated, and I'm just like, calm down, because he has ADHD. And so we get home and we finally sit down for dinner, we say our prayers and everything. And he decided to get some Lysol and disinfect her burger because it was during COVID. And so he was just acting up. I sent him to his room. He goes and slams the door, and I'm like, behave. My daughter comes back crying, that he had done something to her toy box, and I said, son, what's wrong with you? And he was just very quiet. I said, well, tell me what happened. Just quiet. And so I didn't mean to hit him as hard. I didn't mean to hit him at all, but I was trying to tell him, like, you need to calm, you need to behave already. You need to, stop messing with your sister. Don't go trying to push her into the deep end. he already went into deep end and kind of sort of drowned, but I was able to, save him. So I wasn't trying to target him. I was trying to make him understand that it's not okay for you to continue acting like this.
And what have you learned from your parenting classes? Because I'm assuming CPS gave you parenting classes?
No, it's voluntary.
Did you do parenting classes?
Yes, ma'am.
Who did you do parenting classes?
It was compadre.
Okay.
So
I like compadre.
and I learned a lot.
What did you learn?
I learned how to calm myself down, don't explode. Take a deep breath, wait a little bit, talk to him, settle him down, right? Try to understand where he went wrong, where we both can try to understand each other. He is very active, he's very compulsive, and that's part of the ADHD that he has from his family, from his mother's side. My daughter is just like me. We're very chill, we're very calm, and he just.
See, you keep saying, so the daughter has the same mother as your son?
Yes.
Okay, and where's the mother in all of this?
She hasn't been active. She has never been present in Tether. I took custody of them when my daughter was out the hospital because she was born with methamphetamine in her system. My baby mama was a drug addict, so
Mother of your children.
yes,
All right, are you employed?
yes, ma'am.
What do you do?
I do renovation and remodeling, demolition work as well.
All right, this is what the court is going to do. 4 years deferred adjudication. There's an affirmative finding of family violence, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. I'm going to give you 200 hours of community service restitution. If you provide your certificate or proof that you completed the compadre parenting course, then I will deem that the community service hours are satisfied.
Thank you, Judge.
There's to be regular reporting by Zoom or in person, regular UAs, field visits, random, one time a month for 3 months. Then if all is going well with the field visits, then we will decrease it to one time every 3 months random. And that will stay in place until further notice. There's to be no harmful or injurious contact with Michael Duran. And probation, is there some, I don't think this is a BIPP issue. This is more a family issue. Is there some type of family counseling that can be?
Donna, I'll look into, I can look into it. And yeah, I can look into it.
Your Honor, he has also started a class, so maybe you can give that to them and see if that would work.
Yes. So I just don't think this is a BIPP course situation. This is more family dynamic situation. All right, probation. Is there anything else he needs? Is there anything else you need from the court to be successful?
No.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go out the record. Good luck to you. You're gonna have to do better. And you're gonna have a lot to make up to with your son, because believe it or not, I know you say things are better, yes, but your son is always going to remember that. So you're going to have to make it up to him and let him know.
He saw me get arrested in March and he's like, Dad, I didn't mean to get you in trouble. And he's like, Dad, every time the cops come, he's like, are you gonna go to jail?
Yeah.
I don't want him to be thinking that.
No, but see, you got to turn that around and not let him make it his fault, because him saying that is him saying it's my fault, and it's not. Okay? All right, good luck to you.
Thank you, Judge.
All right, can I see the file? What is your client?